Good afternoon. Welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. To my right is Judge Jeff Carpenter. To my left is Judge April Wood. And assisting us today is Senior Deputy Clerk Eddie Sanders. Tom, would you mind getting that door, please? And then here today with us is Officer Tom Salou. On the calendar this afternoon, we have the case of Lisa Biggs individually and as administratrix of the estate of Kelwin Biggs versus Erie Insurance Exchange, Boulevard Pre-Owned, Inc., and Darrell Brooks on appeal from the Durham County Superior Court. Are counsel ready to proceed? Have you reserved time for rebuttal?
Yes, Your Honor.
How much?
15 minutes, Your Honor.
Okay.
15 for rebuttal. Wow.
I don't, did you say 15 minutes?
That's correct, Your Honor.
I'm not, are we allowed to do that? I don't think we can exceed 10 minutes, can we? It can go up to 15? Okay. We'll do it.
Okay. Good afternoon, Your Honors, and may it please the Court. My name is Jeffrey Marcus, here on behalf of Erie Insurance Exchange, and this matter comes before the Court on a order regarding a motion to dismiss regarding Erie's colorable assertion of collateral estoppel. As some background, this is Ms. Lisa Biggs filed a declaratory judgment action against Erie Insurance Exchange, Boulevard Pre-Owned, and Darrell Brooks. From the get-go, to explain, Erie Insurance issued a garage auto policy to Boulevard Pre-Owned, Inc., as its named insured. And I kind of want to bring the Court back to the underlying case and the procedural history. So the background behind this case is that on January 8th, 2015, a vehicle was sold by Boulevard Pre-Owned, Inc. to Nathaniel Brooks. And on January 8th, 2015, Nathaniel Brooks executed a bill of sale, signed and notarized a dealer's reassignment of title to a motor vehicle and other documents necessary, including insurance for this motor vehicle, which is a 1995 Chevy Camaro. After executing these documents, Nathaniel Brooks instructed his son, Darrell Brooks, to pick up the vehicle from the dealership, Boulevard Pre-Owned, and he did so. Now, 2 months later, on March 11, 2015, Darrell Brooks was driving the 1995 Chevy Camaro and got into a motor vehicle accident. And in addition to that, during the time frame between January 8, 2015 through March 11, 2015, Boulevard Pre-Owned tried to send the NCDMV to deliver the certificate of title. However, the DMV rejected it as it didn't have a copy of Mr. Nathaniel Brooks' driver's license. And Boulevard Pre-Owned misplaced that copy of it. Now, Boulevard Pre-Owned didn't sit and just say, oh, well, they tried 8 times to contact Mr. Nathaniel Brooks to obtain that copy.
But in the meantime, the title was still in the name of Boulevard Pre-Owned, right? Because they misplaced this driver's license that they were supposed to have a copy of. They then couldn't transfer the title.
Your Honor, we would disagree with that based on NC General Statute.
You would disagree that the title was still in the name of Boulevard? I understand your argument is about who is the owner, but the
title owner. Correct, Your Honor. The title owner, but not the legal owner, based on North Carolina General Statute Section 20-4.01, subsection 26, which talks about a contract for sale. But the big issue in this case...
Wait, excuse me. So is it your contention then that the paperwork completed in this case was sufficient to transfer ownership?
That's correct, Your Honor.
And you cite Bassett in support of that proposition, right?
So actually we cite Bassett and it's a distinguishable case for one reason only, and I'm glad you brought that up, is that and I want to get the name right, the dealer's reassignment of title to a motor vehicle in Bicette was not signed or notarized. You didn't have a completion of the sale. And this court actually analyzed that in its August 16, 2022 opinion as to the documents that were executed, signed by Mr. Nathaniel Brooks, and as to why this court found that Boulevard Pre-Owned, and I want to get the language right, relinquished authority and control over the Camaro when it completed the sale and title transfer paperwork on January 8th, 2015, and that Darrell Brooks, when he drove the Camaro off Boulevard's lot, was doing so on behalf of his relative, his father, Nathaniel Brooks, who was the buyer of the Camaro and now had authority and control over the vehicle. Thus, the undisputed evidence demonstrates that it was not Boulevard who entrusted Darrell Brooks with the use of the Camaro at the time, but instead Nathaniel Brooks. So once he signed that dealer reassignment, and it was notarized, stamped notarized, that was the completion of the sale. An individual purchasing a vehicle should not be absolved from liability just because they don't want to answer the phone. Yes, maybe the dealership misplaced. I mean, paperwork gets misplaced. Should they have? No, but at the same time, they shouldn't be absolved. The purchaser shouldn't be absolved of liability by not responding to the dealers and trying to transfer the title.
Purchaser's not absolved of liability. Purchaser's sitting under a $10 million judgment. The question is whether there's any liability or any obligation on the part of the insurance company to cover part of that judgment.
Well, Your Honor, to clarify, it's not the purchaser who is absolved of liability, who's on the hook for the $10 million judgment. He was dismissed with prejudice in this case, from my understanding, due to insurance. It's the son, who's not the purchaser, who was just driving the vehicle. So, although not an argument that is brought up in this matter at the current time, but that's the exact reason why in auto insurance policies, there's a provision that has a newly acquired auto and how it replaces the insurance. So the newly acquired auto, because when Mr. Nathaniel Brooks purchased the vehicle and Mr. Dale Brooks took it off the lot, that was a newly acquired auto. He had to have insurance. That's in the, I believe it's in the bill of sales where it talks about the insurance that Nathaniel Brooks had to have. So the newly acquired auto, it doesn't absolve the purchaser from liability, but it's there to show that a dealership shouldn't be put on the hook for being liable because of a 2-month gap where it didn't deliver all paperwork necessary to the DMV.
I got 2 questions for you. First question
Absolutely.
is, this appears to be an interlocutory appeal.
Correct, Your Honor.
How do we have jurisdiction to hear it?
Your Honor, and we cited a case that the Samelka case talks about interlocutory appeals, and as long as there's a culpable assertion of collateral estoppel made, which we believe we asserted in our brief. I know Mrs. Biggs' counsel kind of briefed that a bit, and in their memorandum of additional authorities, which was their amended one, which was filed Sunday, they have the case of Whitehurst. They also talk about Samelka as well. And in these cases, they don't look at just the statement of appellate jurisdiction. This court actually looked at the opening brief in its entirety, and Erie asserts that we have made that colorable assertion, specifically that the Court of Appeals has said that Boulevard relinquished authority and control over the vehicle. And if you look at
But I'm looking at your brief, and it looks like in the statement of basis for appellate jurisdiction, you don't say anywhere that basically this has affected a substantial right for you. It's just you're citing case law, and you cite some case law that says the affirmative defense of collateral estoppel can affect a substantial right. But you don't say it has affected a substantial right in your case. How do you respond to that?
Yes, Your Honor, for that, it's specifically in the section of appellate jurisdiction. It might, let me just clarify. Might not be specifically stated, explicitly stated, but the argument contained within the brief in itself shows that it affects a substantial right because it is for the colorable assertion of collateral estoppel, it's something that's already been adjudicated. The idea of entrustment and permission, the foundation of that is that you have to have authority and control over something. You have to be able to have something to give something. And that we made that colorable assertion of collateral estoppel and then how it would affect a substantial right because it's essentially relitigating this issue of permission that's already been decided.
Which affects your substantial right to what?
It affects the substantial right as Erie asserts that Darrell Brooks is not an insured under the policy. It's essentially causing Erie to relitigate a case in which an issue, especially that Boulevard pre-owned and Kyle Allis, the president, have already been dismissed in the prior action. So this is a second, maybe third bite at the apple as to trying to get money from a judgment where the same issue has already been decided.
In Doe versus City of Charlotte, this court held that you have to actually argue substantial right and show that the substantial right's been affected. And of course, there are exceptions to that, such as sovereign immunity. Is collateral estoppel one of those exceptions?
Your Honor, I believe that the case that we cited, and I believe it's Melka, but I could be mistaken. I apologize, Your Honor. That Samelka talks about that an affirmative defense of collateral estoppel can affect a substantial right, and that's what we're saying, that here it does affect a substantial right because it causes.
Well, there's a difference between can
Like-
and does.
I understand, Your Honor.
And it can, as in it might affect a substantial right?
Well, Your Honor, it will affect a substantial. It does affect a substantial right of Erie Insurance. As I said, Erie is now relitigating an issue that's already been decided, and again, Your Honors, my co-counsel has prepared further argument on the appellate jurisdiction basis, and so I'll let her address that. But here, Erie asserts that it did affect a substantial right as.
Can you refer me to the page in your brief in which you state that, or is it in the statement of appellate jurisdiction? Statement of basis for appellate jurisdiction?
Your Honor, if I may defer to my co-counsel who has prepared that argument.
Sure.
Ready for my second question?
Yes, Your Honor.
My second question is, correct me if I'm wrong, you're the expert. If the DMV receives the title transfer packet timely, it issues a certificate of title that has the same date as the bill of sale. Is that correct? So the bill of sale and the certificate of title would match if the packet is received timely by, I think it's 20 days, by the DMV.
I believe so, Your Honor. I don't want to assume, but I believe so.
If that had been done, we wouldn't be having this argument now because the title would say it transferred on January 8th, 2015. But in this case, the title was issued, I think, May 15th, 2015,
I think it was
something like that.
I think it was
Sometime in May.
I think it was April. I could be wrong, Your Honor.
Could
but
be sometime after the collision in question.
Correct, Your Honor. But again, if the certificate of title, whether it be 20 days or so, that time period between, say, in hypothetical, the purchase of a vehicle and when a purchaser receives the title itself, that would put essentially the dealership on the hook for whatever time that may be.
Not if it relates back the way I think the law works. If the title issued says, title transferred on January 8th, 2015, because we received it, it's the same. See, the DMV doesn't know whether this was two transactions because it's not within the 20 days. Title was issued by DMV on May 12th, 2015.
And I believe and I may be saying the case wrong, the BATS case talks about the issuance of the title and how that the title by the DMV, they weren't concerned about the actual date in which the title was issued, nor was the concern about when the dealership actually issued or delivered the certificate of title. The focus was on the completion of the sale, the execution of the dealer reassignment, and the notary of the dealer reassignment.
Why do you think the legislature put a day time limit in the statute for transferring title? If taking your argument at what it is, doesn't matter when we issued a title, doesn't matter what the bill of sale does, why do you think the legislature bothered to say you got to do it in 20 days?
Efficiency, Your Honor. It's a procedural fact of, or a fact of issuing a title, making sure it's prompt when, purchase a vehicle finishes the completion of the transaction, not the transaction of buying it, but the receipt. So it's not waiting 2 years down the line and where you're hoping for a title, and some people sell their car earlier rather than later. But
Eating into your time. Go ahead and move on to the rest of your argument.
Your Honor, I'm going to save the rest of my time for a rebuttal for my co-counsel. Thank you, Your Honors.
Good afternoon. May it please the court, my name is Finesse Couch, and I'm here from Durham County for the estate of Mr. Kevin Biggs and also his widow, Miss Lisa Biggs. We submitted a brief, and we've listened also to counsel today, and it is our belief that the council's initial brief in the grounds for the statement for appellate review, as this is an interlocutory appeal, we believe that that brief did not suffice. And we say that because under the North Carolina Rules of Appellate Procedure 28B4, if it's interlocutory, there's supposed to be a statement of the facts, individualized particular facts, and the rule of law that you're saying you're going to suffer or it's going to be affected such that you have a substantial right for the court's immediate intervention such that the issue can't wait until the end of the case for a judgment. There must be some appellate intervention right now. So in the brief, we did not see that in there, and we said so. On top of that, without the appellate jurisdiction from this court to review this interlocutory appeal, we also saw that in some instances in the past, the litigants have tried to use a reply brief as a place to shore up on that and to say, I missed it the first time, but guess what? I know now because I read it in my opponent's brief that I had said this and that, but that's not allowed either. And that's the Larson case and Bartels. We just had the Bartels case, and so we cited that in our memorandum of amended plaintiffs' appellees amended memorandum of additional authorities. So we don't believe that this court can breathe life into it because in order to have this review, you have to comply with the statute. And before today, we were wondering why there was no recitation of the substantial right that the Erie said it suffered. There isn't one. And Erie has never had one trial on the issue regarding whether or not there is insurance and what the type of insurance is that applies to the car driven by the drunk driver who killed our client's husband. Erie has never answered in any court of law regarding whether he had lawful possession or if he had implied permission. We see this case as being closely akin to Bizette, where there was an additional and similar incident in a title transfer, but the delay was even longer. The time between the error with the botched title transfer and the actual collision was more than 90 days. And yes, in this case, there's about 62 days or so. But North Carolina is very specific about the way certificates of title are transferred. In fact, the requirements are mandatory. And because we made a mistake or we thought we did it or we didn't, it does not suffice to transfer title. And so, yes, justices were absolutely on point. This title work didn't go in until April the 27th, and then the new title was issued on May 12th. We're talking about a bill of sale on January 8th of 2015. Now, we've talked about implied consent at the lower court, and I would talk more about this collateral estoppel here today if the court entertains the arguments of our counsel, our opponent. But we see this as not only is there the failure to transfer title, but the title holder is the owner of record in North Carolina. And even though you've heard that North Carolina General Statute 20-4.0126 may say something different, the owner, and especially when we're talking about tort law, liability, and then there is an accident, that sounds more like Nationwide Mutual v. Hayes that says this is not going to be a UCC issue. This is an issue of ownership, and the vehicle itself is the primary coverage in North Carolina, not when you make a mistake. We also cited a case in our amended memorandum of authority called Progressive. Progressive is a case where the mother gave her son her car, but she never took the insurance off of it. So an accident occurs, and even though the son may have tried to get his own insurance as a driver, the court held that since the mother never officially transferred the title, her insurance company had to pay. And so that was part of the issue. In this case, the reason we're here as we see it is that in response to the denial of the appellant's Rule 12b-6 motion to dismiss the appellee's declaratory judgment action, which we had filed to ask for the court's interpretation of what type of insurance applies in this case under the contract, Erie filed this premature in our way of seeing it, but they filed this motion for immediate interlocutory appellate review. And that circles right back to what I began to say at the outset, but they haven't stated the required grounds to invoke and to confer the appellate jurisdiction of this court to take a look at this issue at this stage. And there's no harm that's been articulated that couldn't wait to the end of the case disposition such that then the final judgment could be appealed. We also believe that if you're going to use this defense of collateral estoppel, then there are some real requirements for that. And it's probably one of the subjects in law school that everybody likes the least, and I think that's why I ended up with it. But in collateral estoppel, we're talking about the same issues litigated fully that were necessary in the first case that someone is trying to revisit now and possibly ask for yet a different determination judicially on the very exact same facts. Well, we have different issues this time. We're asking about a declaratory judgment to determine the rights, responsibilities, and liability of the drunk driver as well as the owner of the car, and we are asking the court to instruct us on whether or not there was a duty to defend. And I believe that Mr. Couch is going to talk more about that. But if there were truly this collateral estoppel, I would like to say that we cited the Sykes case for that, and the Chief Justice, Newby, wrote that opinion talking about the doctrine of collateral estoppel. We understand that it's designed to prevent repetitious lawsuits over matters which have been already decided. and have remained substantially the same in terms of factually and legally the issues. The issues are the same as the prior action, as I said. It's been raised and actually litigated, and the issues were material. That's important, not just perfunctory in form, but in substance. The issues were material and relevant to the disposition of the prior action. The determination of the issues in the prior action were necessary and essential. We've never talked about whether or not there was insurance coverage, but I will say that in the last opinion that our counsel has referred the court's opinion to or attention to, I would like to ask if you would look with us on, I believe it's page 2. The opinion begins on page 280, but the paragraphs that seem to be very important to this case begin at paragraph 10 in the opinion that's called 2022-NC-COA 548, and it was the last time that we were here, and the name of that case is Biggs versus Brooks and others. Well, in paragraph 10, the court already has established in terms of the,
I believe this only has to be coordinated. We can just,
get to him.
yes, sir.
Excuse me, please.
We ain't got too much into our time, so.
Thank you. In paragraph 10, although you just heard that the ownership of the car,
Hold on a minute, it's not coming on.
okay, sorry.
Power on the monitors up here, we're not,
There it is.
they're coming on, they're
Thank you.
firing up. We've got the monitors on now, Eddie, we don't have anything on the screens.
I'm just glad to see someone using Elmo. I've been going all around the state, giving CLEs, asking attorneys to use Elmo.
I got it all on.
Except Elmo, I keep telling them Elmo's really easy to use, and this is.
It was working this morning. I had
Was it
oral
working
arguments
this
this
morning?
morning. so.
Okay,
Miles hasn't even
If you want to go ahead.
yes, ma'am, I'm sorry. I don't want to run out of time. I got someone coming up the back. Although the parties undisputed, and I'm reading paragraph 10 on page 282 of the record, and this is from the last decision. Although the parties undisputedly intended to transfer title of the Camaro as part of this sale, that transfer did not happen. And that is the fact here, and that's why when this transfer and this bill of sale is dated January 8th of 2015, and the actual title is not complete until May 12th of 2015. On March the 11th of 2015, when this accident occurred, Erie insured the vehicle that was driven by the drunk driver. So although the parties undisputedly intended to transfer title of the Camaro as part of this sale, that transfer did not happen. When Boulevard submitted the title transfer paperwork to the Division of Motor Vehicles, Boulevard misplaced its copy of Nathaniel Brooks' driver license, and the DMV rejected the title transfer for insufficient documentation. So from late January through March, Boulevard and called Nathaniel Brooks 8 times. Well, I won't trouble the panel with any more of that reading because I like to go down to paragraph 13 that says, as part of the crash investigation, the state notified Boulevard that a vehicle still titled and registered with the company had been involved in an accident. The DMV's License and Theft Bureau later investigated and cited Boulevard for failure to timely deliver title as part of that sale. Number 14, underneath there, after obtaining a copy of, and I'm on page 283, after obtaining a copy of Nathaniel Brooks's driver's license, DMV ultimately transferred title of the Camaro to Nathaniel Brooks. And here it says late April 15th. Well, that's when paperwork went in on April 27th. But this still was long after the collision involving the Camaro. The last time the court made its decision, I would like to draw this panel's attention to page 289 of the record, and there is a footnote there. And inasmuch as the case for the declaratory judgment action is an insurance interpretation contract matter, this footnote clearly says that Biggs also argues that under North Carolina General Statutes 20-279.21b2, the owner of the vehicle is liable for the negligent conduct of the driver where the victim's damages were caused by an accident and resulting from the ownership, maintenance, or use of the owner's vehicle. Section 20-279.21 is not a liability provision, it is an insurance coverage provision. Biggs did not raise this insurance coverage issue in the trial court and cannot assert it for the first time on appeal. We're asserting the insurance matter in the declaratory judgment action, and that's why the requirements of collateral estoppel do not fit. We have different issues, and we've asked the court to look at the coverage as well as the duty to defend, and those were not issues in the former case. Therefore, we submit that collateral estoppel doctrine is inapplicable, and ultimately, we would ask that this court dismiss this interlocutory appeal. I will now turn it over to co-counsel. Thank you very much for your time. I don't move in up here.
May it please the court, Your Honor. Your Honors, my name is C.A. Couch, and I'm here also to argue on behalf of the plaintiff appellee, Ms. Lisa Biggs. As Ms. Couch stated, this appeal should be dismissed for multiple reasons, the first being lack of appellate jurisdiction, and second, lack of collateral estoppel on the issue of permission. Two additional reasons why this appeal should be dismissed is because Erie breached its duties to defend and indemnify Darrell Brooks in the underlying lawsuit. That breach makes them responsible for the judgment up to its policy limits. And also, we asked in our amended complaint, and there exists mandatory coverage under the North Carolina Motor Vehicle Safety and Financial Responsibility Act. As it relates to the duties to defend and indemnify, it arises for an insurance company when two conditions are met. And I'm quoting now Waste Management of Carolinas Incorporated versus Peerless Insurance Corporation's 1986 North Carolina Supreme Court case. Quote, when the pleading state facts demonstrating that the alleged injury is covered by the policy, then the insurer has a duty to defend whether or not the insured is ultimately liable. Also, the insurance company needs to have proper notice. In the Cubitt v. Mag Mutual Insurance Corporation case, 2011 case decided by this court, it states that the insurer receives actual notice of the underlying action is when the duty triggers. So here, when applying the facts of this case to these two provisions of the law, in the omnibus clause found on record page 46, which is the policy of Boulevard Pre-Owned, Erie's policy, under the persons we protect section, it lists and states verbatim, the term, quote, anyone we protect means any person or organization listed below. First, they list you, and the next is anyone else while using an auto we insure with your permission. So when you line up the pleadings in this case that were pled in the underlying action, and you line up the policy, it was alleged in the complaint, the original underlying complaint, record pages 83 and 84, paragraphs 22, 25 through 27, that Boulevard owned the subject vehicle, and Boulevard is the insured of Erie.
Let me ask you a question.
Yes,
If we were to get past the jurisdictional issue to reach the merits of this case, what is your position on the issue that is raised by Erie, that under the Financial Responsibility Act and see General Statute 20-4.0126, owner is actually defined under that statute as a person holding legal title to a vehicle, which at this point would have been Boulevard, but it goes on to say, or in the event a vehicle is the subject of a chattel mortgage or an agreement for the conditional sale or lease thereof, or other like agreement with the right to purchase upon performance of the conditions stated in the agreement, and with the immediate right of possession vested in the mortgagor, conditional vendee or leasee, said mortgagor, conditional vendee or leasee shall be deemed the owner for the purpose of this chapter. So what is your position on that definition of owner?
Yes, Your Honor. Under the North Carolina Motor Vehicle Safety and Responsibility Act, Financial Responsibility Act, coverage is written to be inclusive of coverage. So if it's or, that language is, if it should have been excluded, that should be in the policy itself. There's no exclusionary language of that sort in the actual policy. And the case that says that such freedom and construe liberally to provide coverage is State Capital Insurance Company v. Nationwide Mutual Insurance Company, which is a North Carolina Supreme Court 1986 case. So the fact that it's or, it would have to say neither in the policy, but since or applies, and since their insured was the record title owner, then it was their car and they are the owner of the vehicle. I want to also let the court know that we allege in the complaint that Boulevard owned the subject vehicle, that it gave the vehicle to Darrell Brooks. It's alleged that Darrell Brooks operated the vehicle with Boulevard's permission, and it was also alleged that Brooks had legal or lawful possession of the vehicle. And that was, again, paragraphs 22, 25 through 27, record pages 83 through 84. There is no controversy, and it's uncontroverted and admitted that Erie received timely notice of the underlying complaint. So the first step is duty to defend. They did, in fact, have a duty to defend, as the complaint allegations fell within the coverage. Next is the duty to indemnify, and this arises when the duty to refusal to defend is unjustified. Duke University v. St. Paul and Marine Insurance Company. It's a 1990 case decided by this court. It states if, quote, a claim is within the coverage of the policy, the insurer's refusal to defend is unjustified, even if it is based upon an honest but mistaken belief that the claim is not covered. That Duke case goes on to say, when an insurer unjustifiably refused to provide a defense, it obligated itself to pay the amount and cost of a reasonable settlement. Wilson v. State Mutual Farm Insurance, which is a 1990s North Carolina Supreme Court case, says that amount of a reasonable settlement can be a judgment up to the policy limits of the insurer. So here, applying the facts again, Erie had a duty to defend Brooks as a tort claim action alleged in the underlying case fell within the policy. Its refusal to do so was unjustified, which now obligates Erie to pay the amount of the judgment up to its policy limits. So therefore, the trial court did not err in dismissing that claim, and dismissing, strike that. Therefore, the trial court did not err in denying Erie's motion to dismiss. There's also coverage available, mandatory coverage, under the North Carolina Motor Vehicle Safety and Financial Responsibility Act. It is the Act of 1953. It's codified as 20-279.1 at Seek. Sutton v. Aetna, a North Carolina 1989 Supreme Court case, is stated in our brief. It states that the purpose of the Financial Responsibility Act is to compensate the innocent victims of financially irresponsible motorists. We talked about Chantos, that its provisions are written into the statute, and in the event that the statute contradicts the policy, the statute provisions prevail, specifically under 20-279.21b2. It states that policies, quote, shall insure the person named therein and any other person as insured using any such motor vehicle or motor vehicles with the expressed or implied permission of such named insured or any other persons in lawful possession against loss from the liability imposed by law, for damages arising out of their ownership, maintenance, or use of such motor vehicles. So the omnibus clause that I talked about earlier, that stated, we protect anyone using your automobile with your permission. Implicit in there is also the fact if someone's using your vehicle with lawful possession. Under McLeod v. Nationwide Mutual Insurance Company, a 1994 decision decided by this court, although garage policies are not specifically addressed, even garage policies have this provision, the Financial Responsibility Act, and the mandatory coverage also is inside of garage policies. Provisions of insurance must be construed liberally. We talked about that. And the fact that lawful possession, that's a lower threshold than permission. If someone's operating a vehicle and they are not doing it illegally, that would satisfy lawful possession. And in fact, the owner's permission is not needed, although here we have a situation where the dealership literally gave the car to Darrell Brooks. Although the accident was many days later, you do not need to have permission that same very day. So either permission or lawful possession, Darrell Brooks was operating either both or at a minimum lawful possession. There are facts to support lawful possession from the record, including but not limited to Boulevard Pre-Owned's responses to the request for admissions. This appears on record page 25, responses number 44 and 45. The dealership admitted neither it or its agents ever report the vehicle as stolen at any time prior to the fatal collision. Further evidence can be found in the amended motion for summary judgment transcript. This is record page 319, pages 9 and 11 through 13 of the transcript. Counsel for Boulevard Pre-Owned said, and I quote, "We are not taking the position that Mr. Brooks stole the vehicle or took it off of our car lot without our permission," anything like that. So we know that Darrell Brooks was convicted of several felonies and misdemeanors involved with driving, including second-degree murder, felony serious injury with a motor vehicle, causing a serious injury with a motor vehicle, reckless driving, driving while license revoked due to impaired driving convictions. And we have evidence that suggests, and it shows, he had permission of BPO and he was in lawful possession. As a result, mandatory coverages exist under 20-279.21b2. Therefore, the appeal should be dismissed for now at least 4 reasons. 1, the statement of grounds for relief in Erie's opening brief lacked reasons to establish appellate jurisdiction. Permission was established in favor of the plaintiff. Erie breached its duties to defend, indemnify, and as a result, it is obligated to pay the judgment up to its policy limits. And there is mandatory coverage in this garage policy through the North Carolina Motor Vehicle Safety and Financial Responsibility Act. Thank you.
Thank you.
I'm sorry, any
No,
further
you're fine.
questions?
You're fine.
Thank you.
Counsel, are you ready to proceed?
I almost said good morning. Good afternoon, Your Honors. My name is Natasha Durkee. I, along with Jeffrey Marcus, represent Erie Insurance Exchange.
And so in light of Doe versus City of Charlotte, how do we have jurisdiction here?
Yes, Your Honor. I believe we have jurisdiction, or the court has jurisdiction here, for the same reasons as the court noted in Smelka, that the statement of grounds for appellate review in Smelka, it was enough to state that a culpable assertion of collateral estoppel, that was enough. If the argument throughout the brief, not just within the statement of jurisdiction, Your Honor, that as long as it was within the assertion or the argument throughout the brief, it could show that collateral estoppel would apply, then the court had jurisdiction in Smelka, in Whitner, which was just recently cited by the appellant. In those cases, they went outside of just what the statement of jurisdiction stated. And Your Honor, we cited,
Excuse me, so are you saying that collateral estoppel is an exception to the Doe requirement, that the party has to fully argue what substantial right will be affected?
yes, Your Honor, I believe that the case law cited throughout many cases in regards to collateral estoppel that this Court of Appeals has heard, in Turner, Smelka, Whitner, it was enough that as long as a colorable assertion throughout the brief was made of collateral estoppel, that was enough, Your Honor.
Is there any case stating that collateral estoppel is an exception to the rule that you have to argue what substantial right will be affected?
In those exact words, no, Your Honor. There's no case law that I've found that specifically states it is an exception, Your Honor. However, time and time again, this court has looked beyond just what it stated in the statement of jurisdiction, looked at the facts and the arguments made throughout a brief, and in the initial brief, which we have done, that a colorable assertion of the argument in and of itself was sufficient, and I think we've met that, Your Honor.
Well, did you actually state that a substantial right, your client's substantial right would be affected?
Yes, Your Honor. We stated in our initial brief, Your Honor, we stated that a trial court's order rejecting the affirmative defense of collateral estoppel can affect a substantial right, so long as the party asserting the doctrine of collateral estoppel has made a colorable argument that the doctrine applies. And then we cited Semelka. In Semelka, Your Honor, the brief was the same. It stated in Semelka, in which the court ultimately did review the colorable assertion of the argument of collateral estoppel and then ruled in regards to that argument, Your Honor. So it actually did look to the merits. And in that case, Your Honor, the brief in and of itself was similar to what we have done here, Your Honor. And that states, I just want to make sure I'm stating it right, Your Honor. And I've lost the page. But ultimately, Your Honor, it was a very similar line in that brief, Your Honor, and it said, I found it, the court had jurisdiction because defendants made a colorable assertion of collateral estoppel. And then they cited to Turner v. Hammocks. So it's nearly identical to what we've done in our brief, Your Honor. And in that court, in Semelka, this court did go on to review the actual merits of the colorable assertion for collateral estoppel. So I would argue that we have done that here, Your Honor. This court can review it, and it's sufficient. I did also want to address in regards to the title and the registration, Your Honor. So we did not initially cite to the case that was ultimately cited to by appellant, but in that case, it was different because that case held that there was no notary, and the certificate of title was not even executed. Here, Your Honor, that's not the case. The dealership of reassignment of title to a motor vehicle was executed by Nathaniel Brooks. It was notarized, and it effectively transferred the title. It specifically states that the undersigned hereby certifies that the vehicle described in this title has been transferred to the following printed name and address, Nathaniel Brooks. Insurance was acquired, and that is how Darrell Brooks, on behalf of Nathaniel Brooks, drove the vehicle off the lot because the title paperwork had been executed, had been notarized, and insurance had been acquired on that vehicle by Nathaniel Brooks. If ultimately, Your Honor, what the appellant is asking this court to do essentially is to require all dealerships of any size. In this case, it's a small dealership, doesn't execute many cars or sell many cars in a month, but we could be talking, we would be opening Pandora's box to allow a motor vehicle dealership of Subaru, Honda, that any time they were to sell a vehicle, to execute a dealership reassignment of a vehicle, and to have all of the proper documents, insurance to have been properly relayed to this vehicle on behalf of the buyer, it would still not be sufficient. We would still have to wait until title paperwork is obtained from the DMV in the mail, or an actual certificate of title, which can take 30 days, 40 days. I mean, I've personally gone to the DMV, and even if you go to the DMV today, you would not be able to obtain a formal paperwork. You would have to wait for it to come in the mail and to be ultimately handed what the actual form document is. In this case, the individual, Darrell Brooks, on behalf of Nathaniel Brooks, drove the motor vehicle off of its lot, of the Erie's insured's lot, with a dealer. It was not a dealership plate, and that was another distinguished. In the cases that were cited to by the appellant, the vehicle was using a dealership plate. That's not the case here. We had a temporary plate that had been issued to Nathaniel Brooks that was on the vehicle. So there are several distinguishing factors in this case that did happen that ultimately allowed that transfer of title of that vehicle to occur. And ultimately, Your Honor.
Of the accident, though, the registered owner was still the dealership, isn't that correct?
Well, Your Honor.
That was 2 months later, well past the 20 days that the dealership was given to submit all the paperwork to DMV to get the transfer.
In the registration in and of itself, yes, Your Honor. But that just because the registration had not yet been finalized or issued, and that's exactly what happened in Batts, Your Honor. In Batts, the issuance of the registration had not yet been issued, but that didn't make the certificate of title or the title paperwork or the transfer of the title inapplicable. All of those things were still ultimately there, and the sale of the vehicle did occur, just like as it did in this case, Your Honor. And as to, if I may move now to ultimately the reason we're here, which is collateral estoppel. Entrustment in this court, in the Court of Appeals, in the underlying action, when the motion for summary judgment was appealed by the plaintiff in that case, the court held that there was ultimately no evidence that Boulevard had relinquished authority and control over the Camaro when it had completed the sale and title paperwork on January 8th of 2015, and that Darrell Brooks, when he drove the Camaro off of the lot, was doing so on behalf of his relative, Nathaniel Brooks, who was the buyer and now had authority and control over the vehicle. So Boulevard no longer had control or authority over the vehicle. And entrustment and permission, in order to have entrustment or in order to entrust the vehicle over to an individual, if I were to give it to my husband and I'm trusting him my vehicle to go and drive it, and I provide him that consent, that's what's needed to entrust the vehicle over. And in this case, Your Honor, we're looking at permission. But consent and permission is a distinction without a difference. Ultimately, it's the same thing. And here, to hold different or to, in this case, rule that although there's no consent and therefore could not be entrustment, you can yet still have permission, we would be undoing what this court, we'd have two judgments that were ultimately different, but on the same issue. And so, Your Honor, I do believe that collateral estoppel here would apply. The issue is identical. The issue was raised and litigated in the underlying action.
You say the issue, tell me what that issue was.
Whether or not permission was provided by Boulevard to Mr. Brooks.
That was in the vein of determining whether or not there would be proximate cause as to the dealership in a negligence action. We're talking about insurance coverage issues here. So tell me how those two are the same. Yes,
Your Honor. Well, so in order for entrustment, for the purpose of establishing a claim or negligent entrustment, under this doctrine, it requires consent from the defendant. And without that consent, you cannot negligently entrust a vehicle. And I think that's key. Because in the insurance context, in order for...
This is not a negligence case. The negligence case is resolved.
Correct.
It's over.
Correct.
This is an insurance coverage case. This is a contracts case.
Yes, Your Honor. And under the plain language of the contract at issue here, Your Honor, in order for an insured, or in order for there to be coverage under the four terms of the contract, of the policy, there needs to have been consent or permission provided by the insured, which here would be Boulevard, to the individual who was driving the vehicle. And although there is not a negligent aspect in this coverage action as to whether or not the vehicle was driven negligently or negligently entrusted, the issue of whether or not Boulevard consented or provided that permission, whether that be implied or expressed, is the same. The terms of the contract and the case law and the statutes of coverage require that consent be provided from the insured in order to have coverage under the policy for the driver at the time of the accident. And here, you have no consent, you have no permission, whether implied or explicit, based upon the same authority that this court has already declared, that there is no authority and that consent or permission could not be provided by Erie's insured, by Boulevard, as Boulevard no longer had authority or control over that vehicle. And so if the insured, which would have been Boulevard, no longer had authority or control over the vehicle that's at issue, then Boulevard could not have issued its permission or consent, nor negligently entrust the vehicle to the driver on the date of the accident, because it no longer had the authority or control of it to do so.
That's an argument for the trial court, though, isn't it? We're talking about whether or not the issues are the same, meeting the elements of collateral estoppel. How would you have us deal with the language in the Biggs versus Brooks case in the footnote, where another panel of this court said Biggs did not raise this insurance coverage issue in the trial court and cannot assert it for the first time on appeal?
My reading of that, Your Honor, which this court has done many times before, is that the court would not address the topic. Not that it didn't believe that it would apply, but that they would not address it in that context. Not that consent or negligently entrustment, which needs that consent, is not one and the same as with permission. I believe that that footnote, Your Honor, shows that the court would not touch upon the merits of that assertion within its brief, because that was not argued, but it did not that the issue is precluded or has not already been addressed as to consent, which is the same thing as permission. And with that, Your Honor, we would ask that this court ultimately reverse the underlying court's decision on our motion to dismiss and provide Erie with the, I guess, overturn the motion to dismiss in the order that was entered. Thank you. Any further questions? Thank you.
Thank you. That concludes oral argument. We'll take this matter under advisement. Mr. Sanders, we may adjourn.
It was a pleasure.